Welcome to Defenses to Negligence, video 1 of 2. In this video, we will discuss allocation of responsibility, removing from liability, which we completed in the previous modules, toward limitations on damage awards. So, you ready? Let's get started. Until now, we've been asking one question, and that question is whether the defendant is negligently liable, right? Whether the defendant is negligently liable. We've started from the beginning. Does the defendant owe a duty? If the defendant owes a duty, what is the standard of care? Once we've determined that the defendant owes a duty and the standard of care is identified, we move to the second element, which is, did the defendant breach their duty of care? Meaning, did the defendant's conduct or the defendant's behavior or the defendant's actions under those circumstances, same and similar circumstances, did it fall beneath the expected standard of care? If it fell beneath the expected standard of care, then we have a breach. Once we move from breach, we now have to look to see if the defendant's breach is the actual cause of the plaintiff's injury. We understand in the restatement third of torts world, there's only one way to establish actual cause, and that's the but-for test. Now, I might have a restatement third of torts but-for section 26 cause or a 27 cause when I have an illogical outcome, or a 28 but-for cause if I have a situation where there's a lack of proof, right? But there's only one test under the restatement third of torts, that's but-for. Once I've established that the defendant's actions is a necessary component, right? That counter reality test that we do for but-for, I now have to determine proximate cause. Once proximate cause is established, we then move to damages, which is the volume that we just completed, and now we're done, right? The plaintiff has established their prima facie case, and the plaintiff wins, right? Wrong. We now get to the second question. And what is the second question? The second question is, what if the plaintiff helped cause their own injury, right? We've established liability against the defendant, but what if the plaintiff has helped cause their own injury? Now we have to examine the plaintiff's responsibility, right? Negligence law does not stop once liability has been established. Once the plaintiff establishes a prima facie case of negligence liability against the defendant, if the defendant asserts an affirmative defense, then the law must determine, one, did the plaintiff act in a manner that caused unreasonable risk to themselves? Two, did the plaintiff's unreasonable risk conduct contribute to their own injury? Three, if so, then what is the legal consequence going to be? Why do we take into consideration the second question, right? Isn't it enough to establish by clear and convincing evidence that the defendant is liable? Isn't that enough? No, it's not enough, because we understand that accidents are rarely caused just by one person. accidents often emerge as a chain of decisions that converge into plaintiff's injury. And because we understand that that is more often the case than not, the law has to have a process by which we are going to determine how to share liability responsibility between the plaintiff and the defendant. All right. So let's talk about the core principle of this allocation of responsibility. What exactly is it that we're saying? The allocation of responsibility is the governing principle for how we are going to divide up the responsibility of this liability when the plaintiff plays a role in their own injury, right? Again, negligence law is not just about identifying wrongdoing, it's about allocating responsibility. Remember, this is not criminal law. We're not looking to establish wrongdoing and then punish. Civil law is looking to identify the wrongdoing and allocating some responsibility to it, right? There needs to be some accountability for the wrongdoing. Allocation of responsibility requires us to compare the liability that is caused by the defendant with the liability that is contributed by the negligence. Okay. Now, remember though, in this step, we are no longer asking, is the defendant liable? That's already been established. We are now asking if the plaintiff is also liable, which of the parties is going to bear how much responsibility, right? What is going to be the proportion of that liability that is going to be distributed between the parties? There are three doctrines primarily that we are going to focus on that focus on the distribution of that liability. There's three doctrines. One, contributory negligence. Two, comparative negligence. Three, assumption of the risk. I'll say it again. One, contributory negligence. Two, comparative negligence. Three, assumption of the risk. Each doctrine asks, or actually answers, the same question. What happens when the plaintiff contributes to their own injury, right? What happens when the plaintiff contributes to their own injury? Each of these three doctrines reflects a different philosophy about responsibility, different legal philosophy. Contributory negligence embraces the philosophy of if the plaintiff contributes, then the plaintiff is barred. That's barred from recovery. Comparative negligence embraces the philosophy of flexibility and proportionality. Assumption of the risk embraces the philosophy of plaintiff consent. Okay, so these are not just rules of law, they are actually competing visions of fairness, competing visions of fairness. Each doctrine reflects a different way of thinking, right? Each doctrine reflects a different way of thinking. These doctrines are not arbitrary, they are policy choices. Each of the three answers a fundamental question. How should the law treat a plaintiff who is partly responsible for their own injury? How should the law treat them? Well, Let's match the doctrine with the philosophy. Contributory negligence says, again, any fault of the plaintiff contributing to their own injury is too much. So the result, no recovery. Comparative negligence says, fault should be measured and apportioned. Assumption of the risk says, if you, being the plaintiff, knowingly accept the danger, the law may not protect you. So, what we're really studying here is not just doctrine. We are studying how the law defines fairness in a shared fault situation, right? So, this is much larger than just memorizing rule of law, right? This is really an opportunity to look at how the law addresses shared responsibility. Contributory negligence is going to be really, really, really easy. Let me explain it to you this way. In the doctrine of contributory negligence, that's the all or nothing rule. That's the rule that says if the plaintiff shares any responsibility, then the plaintiff is barred. Okay. Under the doctrine of contributory negligence, the rule is simple and it's unforgiving. Again, if the plaintiff has any liability, they are completely barred. I like to give this example, even though it's a bit extreme. I like to give this example. Let's say you have two actors. You've got the defendant and you've got the plaintiff. Let's say, for purposes of example, that the defendant is 99% negligently liable. And let's say the plaintiff is 1%. In that situation, under the doctrine of contributory negligence, guess what? Plaintiff takes nothing. The plaintiff is barred. That's why contributory negligence is simple. Most jurisdictions have abolished it. That's all we have to say about contributory negligence. Most jurisdictions have abolished it. Not all jurisdictions. So heed my warning. If you are in a state that embraces or still adopts contributory negligence, then that's the rule of law that you're going to apply. But don't forget your hierarchy of authority. If there is a statute, you're going to apply the jurisdiction statute. If there is no statute, you then look to the restatement third of torts, provided that the restatement third of torts for that provision has been published. Remember, we didn't use the restatement third of torts for intentional torts last semester because that section of the restatement third is still under draft. But when it comes to negligence, we've been using the restatement third of torts because it's the most recent rule of law and it's been published. Okay. Contributory negligence, for testing purposes, it's been abolished. I explained what it was so that you would know what it was, but that's all we have to say about it. Let's move on to comparative negligence. Comparative negligence is the philosophy of proportional fault, right? Comparative negligence rejects the harshness of the all or nothing approach that we saw in contributory negligence, and instead, comparative negligence asks this question: how much fault belongs to the plaintiff? How much fault belongs to the defendant? How much fault belongs to the plaintiff? How much fault belongs to the defendant? And once that comparison is made, and once that proportionality is assigned, depending upon whether you're in a pure comparative state or jurisdiction or a modified comparative state or jurisdiction, the plaintiff may receive a recovery for the damages that is reduced by the proportion of their share, right? I'll give you more specific examples in just a few slides. Let's go ahead and move on to assumption of the risk. With assumption of the risk, we have the plaintiff voluntarily, right, engaging with a known danger. Assumption of the risk focuses not on the carelessness of the plaintiff, but on the choice of the plaintiff. Did the plaintiff knowingly and voluntarily encounter a known unreasonable risk? If so, recovery may be reduced. Hear what I said? May be reduced. Some cases, it may be completely barred. Again, we're going to do a deep dive of all of these, starting with this slide, slide number 12. Again, contributory negligence, don't really have a lot to say about it. Under that doctrine, if the plaintiff was negligent at any level, right? At any level, and that negligence contributed in any way to their injury, recovery was barred. Done and done. In fact, I had to go back to the restatement second of torts to get section 463 because contributory negligence is not included in the restatement third of torts. Got it? All right, let's move to comparative negligence. What's going on with comparative negligence? This is the restatement third of torts. And you know that, number one, you can tell that I cut and pasted because I want to give you the rule of law. You don't have to paraphrase it. Let me give it to you, okay? You know it's the restatement third of torts because right here, restatement third of torts. What section? Apportionment of liability. What topic? Topic 1. What section? 7. That is the effect of plaintiff's negligence when plaintiff suffers an indivisible injury. I know it doesn't on its face just simply say comparative negligence. Well, welcome to the practice. Plaintiff's negligence, or the negligence of another person for whose negligence the plaintiff is responsible, that is a legal cause of an indivisible injury to the plaintiff, reduces the plaintiff's recovery in proportion to the share of responsibility. Boom. That is comparative negligence, right? Plaintiff's negligence, that is the legal cause of an indivisible injury to the plaintiff, reduces the plaintiff's recovery in proportion to the share of the plaintiff's responsibility. There it is, right? I included in this capture history and definitions. This is comment A. I tell you how important the comments are. Comment A. This section provides the basic principle of comparative responsibility. Ding, 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 ding. And it says specifically, it replaces the rule of contributory negligence, right? Which was the restatement second of tort 467. But that's comparative negligence. Now, with comparative negligence, I actually have two rules, right? I've got the basic rule that explains that the plaintiff's damage award is going to be reduced in kind, right? In the percentage of the liability that is assigned to the plaintiff. And then restatement third of torts, topic 1, section 8, factors. Don't you love the rule of law, right? Don't you love the rule of law? This is what we call black letter, white paper, rule of law. Now, again, The rule doesn't mean what the rule says until the rule is tested, but we have the rule. All right. What are the factors? Factors for assigning percentages of responsibility to each person whose legal responsibility has been established include A, the nature of the person's risk creating conduct, the nature of the risk creating conduct, that includes awareness or indifference, and B, the strength of the causal connection between the risk creating conduct and the harm. Now, once you start applying these factors to cases, it's going to become more clear. But let's move on. You know me. Well, hopefully, at least by now, you know me. I believe in steps. I believe in practicality. I love that we have rules of law. I love that we get to test and prove the rules of law, right? It's very biblical. You got to test and prove all of it. Don't just take anybody's word for it. You got to test and prove it. Yeah. But as a litigator for the majority of my almost 30-year legal career, as a litigator, I'm very practical. Theory without steps doesn't help me demystify the law, right? So if my job is to help new lawyers, students, demystify these rules of law, you got to give them some steps to break this rule into pieces that can be applied in a way that can be understood and mastered. So I said all of that to say, you know who I am. I want steps. So here's the 7-step algorithm for comparative negligence. Here's the 7-step algorithm for comparative negligence. And what I've built into this algorithm are those factors that restatement third of torts, section 8 tells me that we need to apply. Got it? So we've arrived at what I believe to be the most important operational question in comparative negligence. We've got multiple parties who are liable for the injury. One of the parties includes the plaintiff. How do we divide that responsibility? We're going to apply this algorithm. You ready? All right. Beautiful thing about a video is you can stop it, you can rewind it, you can fast forward it, you can screenshot it, you can capture it, right? You can take pictures of it, you can take your time and take the rule apart. So, step number 1, this is for comparative fault. Step number 1, I've got to identify that the plaintiff had some responsibility in the injury. So as I'm going through the hypothetical, I'm paying attention to the facts. Facts matter, right? What is it that the plaintiff did that created an unreasonable risk that led to their injury? What did plaintiff do? We already know that the defendant's liable. That's not what we're trying to establish here in comparative negligence, which is an affirmative defense. We're trying to establish what the plaintiff's role was. So step 1, I've got to identify the plaintiff's role, identify the plaintiff's fault, right? I've got to determine whether the plaintiff acted unreasonably under the circumstances. Here's a question that you can ask to help your determination. Did the plaintiff have a duty of care? Always. Plaintiff always has a duty of care to themselves, right? Always has a duty of care to themselves. Always has a duty of reasonable care. So the question that I wind up asking is, did the plaintiff breach their duty of reasonable care to themselves. Yeah. Did the plaintiff breach the duty of reasonable care that they had to themselves? If my answer is yes, I go to step 2, which is now I've got to see, is there a causal contribution? Did the plaintiffs breach of their duty to themselves, right, result in the legal cause of the injury? We know how to do legal cause. What's legal cause? What's legal cause? Legal cause. Come on, guys. Legal cause, aka, you can do it, aka proximate cause. Remember, legal cause is proximate cause, right? So I am actually doing a proximate cause evaluation as it relates to the plaintiff's liability. If the plaintiff's negligence was the proximate cause, I'm going to continue in my algorithm. If the plaintiff's negligence was not, right, was not a legal cause, then the plaintiff's proportion is not going to be reduced. Step number 3, I have to identify all the responsible actors. And this is going to make more sense once we apply it to, I believe it's the Bartlett case that we're going to look at. But for the time being, take my word, but put a pin in it, because you're going to prove everything, right? You don't take anybody's word as authority. You prove it yourself. So we're going to put a pin in it for the time being, but we're going to get to prove that we're going to need to look at all of the parties that contribute. But for the time being, we're going to look at the plaintiff and the defendant. Step 4, we're going to evaluate the conduct, right? Let's evaluate the plaintiff's conduct. Was the plaintiff's conduct careless? Was the plaintiff's conduct reckless? Was the plaintiff's conduct intentional, right? Did the plaintiff's conduct occur with the plaintiff having some awareness of this unreasonable risk, right? Was the plaintiff indifferent? And if so, how much? These are just some of the questions. These bullets are giving you an idea of what kind of facts am I looking for to satisfy this leg of the algorithm. Step 5, I'm going to evaluate the strength of the causal connection, right? I'm going to evaluate the strength. This is not a mathematical or a scientific formula. This is an evaluation. So I'm going to evaluate, was the plaintiff's participation the direct cause or an indirect cause? In other words, was it a primary cause or a secondary cause? Was it the cause or was it a contributing cause of the injury? Okay, step 6, I'm going to allocate some percentages. The total must be 100. How do I allocate the percentages? I'm evaluating step 4 and step 5. Okay, let me say one more time. This is my made up algorithm. You might be able to have a process of steps that only include 5 steps. You may even be able to get this reduced down to 3 or 4 steps. But let me say this, you have to have some steps, because the analysis is about the application and the explanation of each step. You can't just get to the answer, yes, plaintiff contributed and plaintiff contributed 40%. How do you come up with that? You got to have a process. So if this process works for you, adopt it. If this process works for you with some modifications, modify it. If this process doesn't work for you, great. come up with another process. But you must have a process that you can test that is going to prove its truth. Got it? Step 7, which is the last step, determine the effect on the plaintiff's recovery. We haven't introduced this language yet, but now is just as good a time as any. When we're speaking about comparative fault, we have to take into consideration whether the jurisdiction is pure comparative fault or if it's modified comparative fault. Pure comparative fault, I'll explain that to you in a moment, or modified comparative fault. It can be modified as a 50-50 comparative fault, or it can be modified as a 51% comparative fault. How are you going to know? Because as I said earlier, all of this is jurisdiction specific. You're going to know because the fact pattern has to tell you. You're going to know because the fact pattern has to tell you. So what did we just do? I just gave you the 7-step algorithm and I explained it. What are those 7 steps? Again, we're looking at fault, cause, we're looking at the actors, we're looking at the blameworthiness, we're looking at the causation, percentages, and recovery. Okay? If you want to have that explained again, stop the video, rewind it, go back to where we start to explain each and every one of those steps. Okay, let's move forward. Here we go. One more time, because 3 times a charm. Step 1. What is it that the plaintiff did? What is it that the plaintiff did, right? Step 2. What was the nature of what they did? What is the nature of what they did? Was it careless? Was it reckless? Was it indifferent? Right? What is the nature of what they did? Step 2 again, right? How much does that matter as it relates to the connection between what the plaintiff did and their injury, right? How much does it matter? Yeah. Step 3, once we get to step 3, what is the strength of that causal connection? What is the strength of the causal connection between the plaintiff's conduct and the harm? How directly related, if at all, is this conduct to the injury? Was it a major contributing factor, kind of like the primary reason for the injury, or was it a minor contributing factor, like a secondary part of the injury, right? Step 4, what are we doing with step 4? We are going to take into consideration what illustration do we have? How do we illustrate what actually has occurred? Yeah. Step 5, we're going to clarify the role. Step 6, we're going to connect section 7. And then step 7, this is something that you've got to be able to do on the bar exam, is you're going to make some decisions about the final percentages and whether or not the plaintiff is going to be able to recover. Let's take this out of the world of theory and let's apply an example. Here's a practice question. A driver was traveling 45 miles an hour in a 35-mile-an-hour residential zone while texting on her phone. So what do we have? We've got a driver who is speeding 15 miles over the speed limit in a residential zone while texting, okay? At the same time, a pedestrian began crossing the street outside of the marked crosswalk while looking down at his phone. What is the pedestrian doing? They are not within the protective boundary of the crosswalk, right? So they're maybe somewhere in the middle of the path. And they too are not paying attention because they're looking down at their phone. The pedestrian did not look up before entering the roadway. The driver strikes the pedestrian, causing serious injuries to the pedestrian. At trial, evidence showed this information. So this is part of the fact pattern, okay? At trial, evidence showed this information. Evidence showed that the driver could have avoided the collision if the driver had been looking up. Evidence shows the pedestrian could have avoided the accident if the pedestrian had looked up. At trial, we have a finding that both parties' conduct contributed to the accident. This particular jurisdiction follows a modified comparative fault rule that bars recovery at the 50% point. So this is a 50-50 modified comparative fault, okay? 50-50 modified comparative fault. What does that mean? If the plaintiff is 50% or less, right, from 0 to 50%, if the plaintiff's contribution is up to 50%, then the plaintiff will be barred. How do I know it's 50%? Because it's a 50% modified comparative. Get it? It tells me modified comparative is 50%. So that means that if I get to 50%, plaintiff doesn't recover. So here's my options. A, the pedestrian is barred from recovery because he was negligent in crossing outside of the crosswalk. B, the pedestrian's recovery will be reduced in proportion to his fault unless his fault exceeds 50%. C, the pedestrian is entitled to full recovery because the driver was also negligent. D, the pedestrian is barred from recovery because both parties were negligent. Right? So what do we have? We have the comparisons of some extremes. Let's say I completely forget the doctrine. I'm having a moment of panic. I'm having a moment of anxiety, and I just can't find my way. Look, check out the common sense. The pedestrian is barred from recovery because he was negligent. That's A. What is that? That's contributory negligence. And we got rid of the bar from recovery because the plaintiff's hands weren't clean. So we know that A is out, right? Let's look at our other extreme. The pedestrian is entitled to full recovery. What are we talking about? We're talking about comparative negligence. So no recovery, that's A. I'm kicking that one to the curb. 100% recovery, that's C. I'm kicking that to the curb. So now, instead of a 25% chance of getting it right, now I've got a 50% chance of getting it right because I've got B and D left. Okay, let's look at D. The pedestrian is barred from recovery because both parties were negligent. That still speaks to that all or nothing. So even if from a test taking strategy, even if I have a brain lapse and I forget my rule, B is the only one that offers any proportionality. B is the only one that offers any proportionality. Now, if you remember the doctrine, you know that the answer is going to be B, right? And you know that the answer is going to be B Because why? Check it out. I'm getting ready to test this algorithm. I don't really need the algorithm for this problem because this problem is really pretty straightforward, but I got to test everything, right? I'm a lawyer. You can't tell me anything is true or not true unless I've done the work and I've tested it myself. So let's test this algorithm. Step one, plaintiff negligence. What is the plaintiff's negligence? Remember, step one, I've got to identify what the plaintiff did that was unreasonably risky for themselves, right? Here's that breach of duty to themselves. One, the pedestrian acted unreasonably by one, crossing outside of the protected boundary of the crosswalk, and two, failing to look as they entered the crosswalk because they were on their phone, right? So is plaintiff negligent? Yes. Check. Let me go to step two. What's step two? Did the plaintiff's unreasonable conduct contribute to their harm? I don't know. Oh, well, let's analyze it. The plaintiff entered the roadway without looking. Yeah. By doing that, the plaintiff placed himself directly in the path of an oncoming vehicle, right? And the facts tell me that the plaintiff could have avoided this accident had they been paying attention. So, yeah, the plaintiff's conduct contributed to their harm. Check. I'm going to move to step three. What's step three? I'm going to identify my actors. I've got the driver who's texting and speeding. I've got the pedestrian who's inattentively crossing, right? I don't have any third parties in this one. I identified all my actors because remember, the percent has to equal 100. Okay. Step four, what was the nature of the plaintiff's blameworthiness? Well, for illustration, I gave you the nature of the blameworthiness for both the driver and the pedestrian, right? So the nature of the driver's negligence was pretty high, right? They are speeding 15 miles over the speed limit in a residential zone. I'm going to say that that's majorly contributing to the plaintiff being run over. Yeah. Let's look at the pedestrian. What is the pedestrian doing? The pedestrian is inattentive and crossing the street. That's significant. But if I'm evaluating, because there's no bright line mathematical calculation, right, for precision, I'm going to say that if I had to rank these, that the driver would probably be the direct cause or the more significant cause, and the pedestrian is significant, but not quite at the same percentage as the driver. I'm going to go to step five, where I look at the strength of the connection, right? The driver's direct cause of impact, the pedestrians also, but not as significant as the driver. Step six, what's the implication? Driver likely bears a greater responsibility, right? Pedestrian bears significant responsibility because they did enter the roadway without looking, but maybe not as significant as speeding, residential zone, texting, and not paying attention. Step seven, I'm going to apply the jurisdictional rule. What is the jurisdictional rule here? Well, we're in a modified system where the plaintiff is barred at 50%, right? We're in a modified system where plaintiff is barred at 50% because step 1 through 6 tells us, right, in our evaluation that plaintiff is part of the problem that led to the injury, their contribution isn't equal, right? Which means what? That the plaintiff's amount of proportionality of the liability is going to be less than 50%. So, since the plaintiff didn't get to the 50% mark, see, plaintiff likely below 50%, because the plaintiff didn't get to the 50% mark, the plaintiff's going to recover, but the recovery is going to be reduced to the proportion that the plaintiff is 47%, 48%, 49%. I promise you it makes sense. You might have to think about it a couple of times. You might have to work through it a couple of times, but I promise you, not only does it make sense, we just proved the algorithm true. Okay. And I tell you here that the answer is B, and there's explanations as to why A, C, and D are not correct. We have another practice question. Let's go through it one more time. A delivery driver was driving slightly above the speed limit while approaching an intersection. Driver approaching an intersection a little bit over the speed limit. At the same time, a cyclist approached the same intersection from a side street controlled by a stop sign. The cyclist failed to come to a complete stop and entered the intersection while wearing headphones and looking down at a navigation device. Yeah, right. I know that your brains, right? Your brains have already said, yeah, 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 yeah. Whatever step that is that I'm going to get to, where I'm going to compare what the plaintiff's proportion is, it's going to be more than 50%. Right. You've already said it. You've already said it. But hold on. Let's just work through the algorithm, because if this isn't a multiple choice question, let's say that this is an essay question, you're going to have that process for your analysis. So let's just go ahead and practice it. What else do we know? We know the driver saw the cyclist at the intersection, but distracted by a notification on the dashboard screen, delayed braking, and the driver struck the cyclist. So the driver saw the cyclist, but was distracted, delayed, and wound up hitting the cyclist. At trial, here's some evidence. The cyclist's failure to stop at the stop sign and inattentiveness, looking at the GPS with the headphones on, placed him directly in the path of traffic. Okay. The driver's delayed reaction increased the severity of the collision. This is what we're being told at trial. This is what we are learning at trial. Either party acting reasonably could have avoided the accident. This jurisdiction follows a modified comparative fault system that bars recovery if the plaintiff's fault is greater than 50%. Is greater than 50%. So what does that mean? That means if the cyclist gets to 50%, they still get to recover for the 50% that they're not responsible, right? The plaintiff's fault has to be greater than 50%. Let's go through the choices. A, the cyclist is barred from recovery because his failure to stop at the stop sign was a direct cause. What does that sound like? He's barred because his hands aren't clean. Sounds like contributory negligence. We know that cannot be the answer, right? B, the cyclist is barred from recovery because his negligence was greater than the driver's as a matter of law. We like that one, but we hadn't figured it out yet. We haven't gone through the process to assess or to allocate the proportionality. So to pick B would be a guess, right? We hadn't gone through the steps. C, the cyclist recovery will be reduced unless his fault is determined to be greater than 50%, which depends on the relative blameworthiness and causal contribution of each party. Yeah, right. That C matches what we've learned, where it says the jurisdiction follows a modified comparative fault system that bears recovery if the plaintiff's fault is greater. C says that the cyclist is going to recover, right, unless it's determined that their fault is greater. So I don't have to work this algorithm out to see that C matches the language that's given in my rule, but I got to look at D. The cyclist is entitled to full recovery because the driver had the last clear chance. Last clear chance, that is a thing. But I get rid of A, right? Because they're barred completely because they were negligent. Well, we don't do that anymore. That's contributory negligence. And I get rid of D because there's full recovery. Not going to be full recovery. Not going to be full recovery because the plaintiff has some assigned proportionality, right? So I'm working with B and C. I like C because it matches the rule. But B also makes sense. The answer C. Let's test it. What is plaintiff's negligence? The cyclist acted unreasonably by failing to stop at a stop sign. They entered the intersection without ensuring it was clear, and they were riding while distracted. They had headphones on and they're looking at a navigation device. Does the plaintiff bear any liability? The answer is yes. Great. Check. Move to the second one. What is the causal contribution of the plaintiff's negligence? Well, let's look at what the cyclist did. You see, when we talk about comparative negligence, our focus is on the plaintiff. Okay. The cyclist's conduct contributed to the harm because the cyclist failed to stop at the stop sign. So that put the cyclist directly in the intersection. And the cyclist's inattentiveness prevented him from being able to navigate around oncoming traffic. If he were looking, he may have been able to navigate around it, right? And we know from the facts that the accident would not have occurred had the cyclist exercised reasonable care. How do we know that? Is that a conclusion? It's not a conclusion. Our facts tell us that, right? Remember, let's go back and look at it. Our facts tell us that either party acting reasonably could have avoided the accident. So the cyclist acting reasonably could have avoided the accident. The driver acting reasonably could have avoided the accident. Yeah? All right. So is plaintiff's negligence the legal cause? Yup. Move forward. Identify the actors. We've got a driver who's speeding. That's the defendant. But we're not really looking at what the driver's doing because we already know that the driver's liable. We're talking about comparative negligence, which means we've got to look at the liability of the plaintiff, right? Cyclist, failure to stop at the stop sign. Ooh, right? Just because you're on a bike doesn't mean you don't have to follow the laws of the roadway. You do. You do. So we've got the cyclist and we've got the driver. So I know that between the two of them, I've got to come up with 100%. Step 4, what is the nature of the plaintiff's blameworthiness? Well, I put the driver and the cyclist here so that you could see the two comparisons, but what we're really focused on here is the cyclist. The cyclist ran the stop sign. That's serious. The cyclist entered the roadway without looking. That's serious. The cyclist is distracted. If I've got to compare, I'm going to say that the cyclist is probably a little more blameworthy, right? Now, that's not to say that the driver's not, but I know that the driver has some liability. I'm looking at the cyclist, and the driver's going a little bit over, but I can't measure a little bit over, right? I know that the cyclist broke a traffic law because they didn't stop at the stop sign. You see what I'm saying? So if I've got to compare them, this is just like the other practice question where the driver was going 45 in a 30. What do I know from that? I can infer from that reasonably they're speeding. Get it? I can infer from the fact that the cyclist didn't stop at the stop sign that they broke a traffic law. That's gonna trump. Okay. That's gonna trump the driver. But let's look at the strength of the causation. Was the cyclist what's going on with the cyclist? Well, the cyclist created the immediate risk, right? Placed himself directly in harm's way. The driver failed to avoid the collision. That's the last clear chance rule. Uh, and may have increased the severity. But I'm still leaning toward the cyclist is going to get beyond that 50-50 mark, right? Both are substantial in contributing to the causes, but in different ways. The cyclist here is really the direct cause, right? The cyclist here is really the direct cause. Okay, well, let's imply some allocation of percentage. The cyclist likely bears significant responsibility. The driver bears substantial responsibility, but it's just not as significant. Now, get it. This one is going to be close, right? This one's going to be close. But when you still look at the seriousness of the cyclist's violation, one being the violation of a traffic law versus the driver's lack of paying attention, the cyclist is going to be more than 50%. Let's apply jurisdiction, modified comparative. The cyclist is going to be barred if it's greater than 50%, right? If it's greater than 50%, barred. If it's 50% or less, recovery. The court that I pulled this from said that the outcome could not be determined as a matter of law because it was way too close and it was going to depend upon the fact finder's allocation, right? Which is an okay answer for an essay, but not an okay answer for multiple choice. And so with a multiple choice, the answer is going to be C. Got it? That's comparative negligence. Okay. We're going to apply the algorithm to two cases. This is the Lee versus Yellow Cab case. And then we're going to apply the algorithm to the Bartlett case. And then we're going to be done with comparative negligence. So just hang in there. The beautiful thing about a video is if you need to stretch your legs, if you need to take a break, if you need to get my voice out of your head, you can stop it at any time. Okay. So Lee v. Yellow Cab is a pretty significant case because this is the case where California abolishes contributory negligence. This is the case where California abolishes the doctrine of contributory negligence and instead adopts a system of comparative negligence. Okay. What are some of the facts? We've got a defendant by the last name of Phillips. The defendant was traveling at approximately 30 miles per hour entering an intersection. Okay. That speed was unsafe at the time and place. This is according to the facts. And the traffic light controlling the southbound traffic, right, which is the direction that the defendant was going, was yellow at the time that the defendant entered the intersection. So we've already got some things against this defendant, right? We've got traveling 30 miles per hour, which was an unsafe speed at that particular time at that place. And we've got the defendant entering an intersection on a yellow, right? No bueno. You're not supposed to do that, right? And so the defendant went through the intersection. The court also found that the plaintiff, however, made a left turn across the southbound lanes. Plaintiff made a left turn across the southbound lanes. At the time that the plaintiff made the left turn, there was a vehicle approaching from the opposite direction, right? That it was so close that we had the creation of an immediate hazard. So what do we have? We've got both the defendant and the plaintiff acting unreasonably. We've got both the defendant and the plaintiff acting unreasonably. So this is going to be a situation where we're going to have comparative negligence. The dispositive conclusion of law was as follows, because this is a case that's already been adjudicated. Miss Lee, the plaintiff, was negligent. Such negligence was a proximate cause, that's legal cause, of the collision. Plaintiff was barred from recovery in the trial court. As a result, the trial court entered a judgment for the defendants, right? The Court of Appeals affirmed the trial court decision in favor of the defendants. Ms. Lee appealed. It got up to the Supreme Court of California, and the Supreme Court of California held that the doctrine of contributory negligence, which would have completely barred the plaintiff's recovery, is abolished. Got it? And instead, it was replaced with a system of pure comparative negligence. Pure comparative negligence is when plaintiff's recovery is reduced in proportion to the plaintiff's percentage. Here's an example. It's awful, but it gets the point across. If the defendant is 99% liable in a pure comparative state, and no, let's reverse that number. In a pure comparative state, if the plaintiff is 99% liable and the defendant is 1%, right? I know that's ridiculously unbalanced, but I do that so that you can see the intent of the rule. Even with that disproportion falling on the responsibility of the plaintiff would recover the 1% because it's pure comparative negligence. Get it? So the holding from Lee is everyone is responsible not only for the result of his willful acts, but also for an injury occasioned to another by his want of ordinary care or skill in the management of his property or person, right? So in other words, we all have a duty of care to ourselves. And if you breach that duty of care to yourself, you're going to hold some responsibility. But at the same time, that responsibility isn't going to bar you from recovery where you are involved with another person who also has some proportion of the responsibility. Get it? Why do we like Lee? It abolished contributory negligence and adopted pure comparative negligence. Oftentimes, what happens in California and New York kind of become the mainstay of the rest of many of the other states, right? So many states have abolished contributory negligence. But for the sake of the practice of it all, let's take the facts from Lee and let's try out our 7-step algorithm. Step one, number one, identify the plaintiff's fault. Did the plaintiff act unreasonably? The plaintiff made a left turn across oncoming traffic, failed to yield, plaintiff breached duty of reasonable care to themselves. So yeah, the plaintiff did act unreasonably. Okay, let's create or let's evaluate the causal contribution of plaintiff's negligence. What's the causal contribution? In other words, did the plaintiff's negligence contribute to the injury? Yeah. Plaintiff's improper turn placed the vehicle in the path of defendant, right, who was entered that intersection on a yellow. Absolutely, right? But there is no question that the defendant bore some liability. Yeah. No question at all. But so did the plaintiff. So the answer is yes, the plaintiff's conduct contributed to the collision. Check. That means I keep going. Let's identify all of the responsible actors. I've got a plaintiff and I've got a defendant. Check. There was nobody else involved. Let's evaluate the nature of plaintiff's blameworthiness. Plaintiff traffic violation, which is a failure to yield, right? It's not the most egregious traffic violation, but nevertheless, it's a traffic violation, right? We know that the defendant was speeding, traffic violation, okay? We know that the defendant entered the intersection on a yellow, could not clear that intersection, right? So technically, defendant read the red light. Yeah. Okay. So what does that mean? That means that both parties are careless, right? But defendant speeding increases the danger, right? Plaintiff's turning increase the danger. So I've got comparable blameworthiness, not identical, but comparable. If you're asking me to assign a proportion right now in step 4, I'm going to say that the defendant is more liable than the plaintiff. But at this point, it doesn't really matter because I'm in a pure comparative negligence state, which means that the plaintiff is going to get something, right? Doesn't matter if it's 50% or 51%, the plaintiff's going to get something. It's just not going to get the portion that the plaintiff has been found to be responsible for. Evaluate the strength, plaintiff direct cause, defendant contributing cause, assign the comparative responsibility, right? This is it. Plaintiff negligent, no recovery. That's if we were still in contributory negligence, but we know that pretty red X is saying that the court got rid of contributory negligence. So we're going to allocate responsibility. We are going to apply the jurisdictional rule, which is pure comparative fault. So the plaintiff's recovery is going to be reduced by the percentage of their liability. Boom and boom, right? So the Supreme Court in Lee reversed the finding of contributory negligence, which barred recovery, remanded back to the trial court to now try the merits of the case utilizing the comparative negligence system. The algorithm works. The algorithm works. Here's the last one, and then we're going to wrap up comparative negligence. You're doing an amazing job. Just hang in there. This is the Bartlett case. And in the Bartlett case, Bartlett is in a jurisdiction that says plaintiff recovers if their contribution is not greater than 50%. What does that mean? That means that they can be up to 50% liable and still recover. As long as they're not greater than 50%, the plaintiff's going to be okay. What's going on in Bartlett? So sorry. Here we go. What's going on in Bartlett? Comparative negligence case, right? Bartlett, we have two issues. One, whether a tortfeasor is liable for all of the damages caused by concurrent tortfeasors, that's joint and several liability. Two, this is the one that's focused on our point, whether the percentage of fault of a non-party, right, concurrent with a tortfeasor is determined by the fact finder. Let's take a look. 3 cars in this accident. The car in front of plaintiff's car signaled a right turn. We call that the lead car. The lead car turned into, right? I'm going to lead car, signal, I'm getting ready to take this right. Going into the right was going into a service station. Lead car turned into the right, right? But in a very fast motion, got back into the line of traffic, back in front of plaintiff's car, right? Get it? Do you see it happening? I'm driving. There's a car in front of me. That car in front of me signals. I slow down a little bit because I realize that the car in front of me is going to need to slow down to take the turn, right? I slow down a little bit. The car in front of me slows down a little bit, takes that turn. Immediately, car in front of me changes their mind and they jump back in front of me, right? Ever happened to you? Now, the driver of the lead car is unknown. The plaintiff, who's behind the lead car, slams on her brakes to keep from hitting the lead car, right? The defendant is in a truck behind the plaintiff. The defendant applies his brakes, but the truck skids and the defendant in the truck rear ends the plaintiff. Got it? Plaintiff sues the defendant on the theory of negligence. The defendant contends, hold on. I ran into the back of the plaintiff's car, but this accident was caused by the unknown driver's reckless or poor behavior. Get it? So the defendant isn't necessarily saying that they are not or that they do not have some proportional liability, but they're saying I shouldn't take all of the liability because some of this was caused by this unknown driver. So we've got an issue statement. Under comparative fault, which requires a trier of fact to allocate responsibility among all the persons, does the fact finder determine the percentage of fault attributable to the non-party, right? Because this is what's going on. Well, let me just go through the procedure history, and the procedure history can explain what's going on. Trial court. Here's a direction that the trial court gave to the jury in the jury charge. If you find for the plaintiff, but also find negligence of the plaintiff and or negligence of the unknown party contributed to cause the accident, then you must decide each party's fault. Get it? If you find that the plaintiff is negligent and or you find that the unknown driver is negligent, then you've got to determine the proportionality of fault for all of the parties. So you're going to have to find the proportionality percentage of fault for the plaintiff, for the unknown driver, and the defendant. Okay. The second charge, the defendant is liable only for the defendant's percentage. The defendant is liable only for the defendant's percentage. Okay. The total amount of damages to the plaintiff would otherwise be entitled shall be reduced in proportion to the percentage of the plaintiff. That's comparative negligence, right? So what's the problem? The problem is the plaintiff says, I've got $100,000 worth of damages. The jury has awarded me accordingly. I want the defendant, the one that we know, to be responsible for that $100,000 worth of damages, because that's what's going to make me whole. Can't help that we don't have an unknown driver, but we've got a known driver who has some liability, and I want the known driver to be jointly and severally liable. Under the doctrine of joint and several liability, if you have multiple tortfeasors, one tortfeasor can be made to pay the entire judgment for the multiple tortfeasors because the goal is to make the plaintiff whole. The goal is to make the plaintiff whole. And if we've got multiple tortfeasors and we've got one tortfeasor who can cover the bill for everybody, then that one who can cover the bill for everybody pays the bill to make whole the plaintiff. Now, if once the plaintiff has been made whole, the defendant who paid the bill for everybody wants to go back and get the proportion that the other defendants owed, they can do that. They can file a separate lawsuit for contribution saying, I paid more than my percentage. This percentage belonged to you. You owe me, you pay me. They can absolutely do that. That's joint and several liability. Let me say this to you about joint and several liability. The majority of the jurisdictions have abolished it. So that's the extent of what I have to say about joint and several liability. Okay. So what do we have back in the Bartlett case? This is what we have, the findings of the jury, right? Court gave an instruction. If the plaintiff's involved, we need her percentage. If the defendant is liable, we need their percentage. If the unknown driver is liable, we need their percentage. We want everybody's percentage. And at the end of the day, the defendant is going to be responsible to whatever percent he's been assigned. The jury found that the plaintiff was 0% responsible, the defendant was 30% responsible, and the unknown driver was 70% responsible because we got to get to 100%. The plaintiff, of course, wants the defendant to pay 100%. The trial court ordered a new trial and said, maybe we need to do something different with our instructions. Okay. The appeals court said, well, hold on. The defendant and the unknown driver are concurrent tortfeasors. So should the defendant be held jointly and severally liable for both the defendant's share and the unknown driver's share equaling 100%? Or should the defendant only be responsible for their 30% share? Here we go. The court held that under comparative fault principles, the fact finder must determine and allocate the percentage of the fault attributable to all persons. That's going to go back to our, I believe it's either step 4 or step 5 in our algorithm, but all persons, including non-parties, right? And the defendant is liable only for the proportion of damage corresponding to the defendant's share. Bartlett is the case for New Mexico that set aside the doctrine of joint and several liability and instead implements several liability only. What is several liability? The defendant is only responsible to pay the portion of the judgment for damages that is equal to their proportion of liability. Got it? Yeah. So pure several liability, that's Bartlett. Joint and several liability. Some states, not many, right? Some states, not many. There's even a few states that have a hybrid system where they will do joint and several liability for economic damages. We talked about economic damages. Those are pecuniary damages. Those are, can you pay my bills? Can you pay my telephone bill? Right. Those, those are uh, those are the money damages that we can calculate, right? Give me the bills, show me the invoice, show me the timesheet where you've lost some wages, right? Uh, and the hybrid again would be where you've got some states that say, well, we'll do joint and several for economic damages, but we're only going to do several for non-economic damages. How are you going to know? You're going to know because you're going to read the fact pattern, and whether it is a hypothetical or whether it's a multiple choice, the fact pattern is going to have to tell you. Now, I'm not going to test joint and several liability because most jurisdictions have abolished it. And again, I'm not testing contributory negligence because most of the states have abolished it. So you don't have to worry about it. Bar exam, not testing joint and several liability. Most states have abolished it. Bar exam, not testing contributory negligence. That's if you're taking one of 49, right? Okay. Last thing we're going to do with comparative negligence is we're going to apply the 7-step algorithm to the Bartlett case. So let's identify the plaintiff's fault. Did the plaintiff act unreasonably? Well, in this situation, you've got the plaintiff acting, if at all, it's fractionally because the jury came back with 0%. So does that mean that there doesn't have to be any comparative negligence applied? No, because we have multiple tortfeasors whose liability has to be proportioned, right? So even though the plaintiff's fault is minimal and we've got a finding of 0, we're going to proceed, but we're going to proceed cautiously because we already know that the liability of the plaintiff is not an issue here, right? Establish the causal contribution. Again, likely no causal contribution because we got the plaintiff at 0. Let's go to step 3, identify all the responsible actors, defendant, non-party, which is the unknown, and then we didn't include the plaintiff because we kind of zeroed the plaintiff out, right? The defendant's negligence, the non-party's negligence, right? We've got the non-party acting the unknown party acting at a greater responsibility. Remember, the jury said that it was 70%. Step 4, we're going to evaluate. Step 5, we've got the non-party stronger. Step 6, right, we're going to assign the comparative responsibility. The non-party had 70%, the defendant had 30%. That is 100%. Apply it, defendant's going to pay the 30%, and then the unknown party is responsible for 70%, but they're an unknown party, which means what? Kind of sucks for the plaintiff in that case. Got it? That is comparative negligence. We've gotten rid of, abolished contributory negligence. We have pure comparative negligence, or we have modified comparative negligence at 50%, and then we have modified comparative negligence at 51%, right? Go through the slide, go through the video. If you have any questions, reach out. The next video will be half as long as this one, because the next video, we're only going to address assumption of the risk. So I look forward to seeing you next video, where we will address the third defense, which is going to be assumption of the risk. I appreciate you. You guys were champions through this one. Look forward to the next video.